Assalamualaikum and good morning to Prof. My name is Sheikh Muhammad Shabil bin S.SHAHRIN with the matrix number of 2023388943. So today I'm going to answering tutorial 3 question 4, which is the question is question 4. Rishi and Sharon, an Indian couple from Malaysia, migrated to England in 1980. They have 2 children, Vimala and Danish. Last year, Vimala met Ramesh, a Malaysian student in London, and they fall in love. Vimala has recently agreed to marry Ramesh, and the marriage ceremony will be held in Malaysia. She also agreed to live in Malaysia. Vimala comes to know that the Indian customary law was part of the Malaysian law. However, she was also informed that the Law Reform Marriage and Divorce Act 1976 has made significant changes to the application of the Indian customary law in Malaysia. The question is, advise Vimala on the effects of the Law Reform Marriage and Divorce Act 1976 on the Indian customary law. So my answer is, to start off, Vimala must adhere and aware about the Law Reform Marriage and Divorce Act 1976 to make sure the marriage is valid. The Law Reform Marriage and Divorce Act 1976 had made significant changes to Chinese and Indians relating to their customary law. The Act regulates and standardizes matters concerning marriage and divorce among the Chinese and Indians. There are 4 effects of the statute on the 2 customary laws that Vimala needs to know, which are abolish polygamous marriage, the registration of marriage, solemnization of marriage, and grounds for divorce. The first effect is the abolish polygamous marriage. In Section 5 and Section 6 had introduced monogamy into the community, which by religion, custom and usage had practiced polygamous marriage. If any person who lawfully married from contracting further marriage during the continuance of the existing marriage, doing so is committing the offence of bigamy, which if found guilty will be imprisoned for 7 years. The second effect is registration of marriage. In Section 33 and Section 34 provides for registration of marriage. This somehow will remove any doubts regarding the status of cohabitees and children of such unions. If the marriage had been done before 1 March 1982, there is no requirement for a couple to register, but it had stated in Section 33 for voluntary registration, and under Section 34 said nothing in the Act shall be construed to render valid or invalid any marriage just because of its having been or not having been registered. To sum up, all customary marriage that were not registered before 1 March 1982 can be considered valid as long it is according to the customary law. This can be seen in the case of Leong Wee Shing versus Chai Siu Yin. The issue was whether the plaintiff's marriage is void for non-registration and the registry of marriage. It was held that Section 34 had been satisfied. There was a property ceremony, an act of marriage, and properly solemnized. Thus, it follows the customary laws. The marriage is still valid, even though it did not register. Section 72 recognized marriage falling outside the Act, but within the customary law. The third effect is the solemnization of marriage. Section 22, subsection 1, subsection C provides that solemnization of a religious or customary marriage may be effected on 2 conditions, which are the person solemnizing the marriage must be a religious officer or person appointed as an assistant registrar, and the couple must submit a statutory declaration to the assistant registrar. Marriage are solemnized in church or temple or clan association premises as may be permitted by the religion or custom or usage of the parties. A registrar may be appointed within this institution to solemnize the marriage, and he will issue a marriage certificate. Otherwise, the couple may marry at the government marriage registry office and then proceed with another customary ceremony. Customary ceremony alone, although recognized and acceptable to the family, it is not sufficient to close a marriage with legal validity after 1 March 1982. The fourth effect is grounds for divorce. There are 3 sections included for the grounds for divorce, which are Section 51, Section 52, and Section 53. Section 51 stated the dissolution on ground of conversion to Islam. When one party from the marriage has converted to Islam, the other party who has not converted can file a petition for divorce, and provided that no petition under this section shall be presented before the expiration of 3 months from the date of the conversion. Next, Section 52 stated the dissolution by mutual consent if husband and wife mutually agree that the marriage should be dissolved. They may present a joint petition after the expiration of 2 years from the date of their marriage, and the court may, if it thinks fit, make a decree of divorce on being satisfied that both parties freely consent and that proper provision is made for the wife and for the support, care, and custody of the children, if any of the marriage, and may attach such condition to the decree of divorce as it thinks fit. Section 53 also stated the breakdown of marriage to be the sole ground for divorce. Party to a marriage may petition for a divorce on the ground that the marriage has irretrievably broken down. The court hearing such petition shall, so far as it reasonably can, inquire into the facts alleged as causing or leading to the breakdown of the marriage, and, if satisfied that the circumstances make it just and reasonable to do so, make decree for its dissolution. In the case of Nancy Kual versus Ho Tao On, the fact was the marriage was contracted both under Chinese and native customary rights between a Chinese man and a native lady, but not registered under the Act. The Chinese husband claimed the marriage was a nullity. It was held that Chinese customary law does not longer apply. However, the court proceeded based on the Native Courts Enactment 1992 and applied the native customary law. The marriage was valid, having complied with laws of the country. In conclusion, the Law Reform, Marriage and Divorce Act 1976 can be applied and used for the Chinese and Indians. Vimala must adhere to the Act to make sure her marriage is valid and did not end up in nullity.